The day 3 of the IFA Congress 2014 Mumbai started with a very interesting session. The second scientific topic, the plenary session for the day was on the qualification of the entities and availability of the treaty benefits, focusing mainly on the fiscally transparent entities, and that's a debate which is relevant even in today's context. We saw two extreme points of view, especially on the relevance of OECD's report published in 1999 on treatment of partnerships which are treated as fiscally transparent. Most of the people on the panel believe that the report has been inadequate, especially to deal with various kinds of fiscally transparent partnerships that have, or fiscally transparent entities that have emerged over the years. On the other hand, Jack Saswell from OECD strongly defended the report, and he believes the scope and the relevance still continues today. Before I go to the other sessions, Shefali, your quick take on fiscally transparent entities treatment, especially in the Indian context. This has been a matter of debate before the courts, especially now that the LLP structures are also coming into effect. Some quick comments, Shefali.
Sure. So it was a very interesting discussion today about how the different courts have taken different approaches to taxation of fiscally transparent entities. And in fact, some of the Indian courts, while largely holding in favor, interpreting the treaties more purposively, have chosen to grant the treaty benefits. At the same time, there have been a few rulings by the Authority for Advanced Ruling where a divergent view has been taken. And you're right, this issue is going to get more pronounced as we go, because there will be a lot of spotlight on how technically and literally interpreting the treaties. Many of these entities may not be able to satisfy the requirements for treaty entitlement, and therefore unless something is done either through a multilateral instrument or by countries coming forward and accepting some of these commentaries which do grant the treaty benefits to the shareholders or the partners of a fiscally transparent entity, this controversy will remain for a while.
Right, and very interestingly, there was an intervention from International Chamber of Commerce representative, and
they brought out a very important point, as to most of the treaties and commentaries only address the juridical double taxation, and they made out a case as to why the treaties now need to focus on the economic double taxation.
Right. Another highlight of this session, Shefali, at least, was a point raised by Mr. Pramod Kumar, the Honorable Judge at the Income Tax Tribunal, is how to resolve these disputes. And he also believes that a sort of interpretational approach through a commentary will not be sufficient to deal with the classification of entities, which is a debate that's something which has to be addressed via the bilateral treaties. And
I agree with him, because the minute you leave it to the interpretation of the courts, there is bound to be inconsistency.
Right.
So you have to have another way of giving more certainty to the taxpayers on these matters.
Right. And one of the solutions he proposed is, can there be a most favored nation clause, MFN clause, which can be introduced for dealing with the issue of treatment of fiscally transparent entity. In other words, if a country takes a view later point in time which is sort of dilutes the threshold for treaty eligibility, then can that view be automatically applied for MFN? And Professor Lang brought out an interesting statistics that MFN is not new. 600 treaties have MFN clause.
Precisely, but there is a defined and pre-agreed scope for the MFN clause. So even for the countries to agree that they would include the treaty entitlement to the fiscally transparent entities, they need to have a bilateral arrangement and agree on the revised scope of the MFN.
Sure.
So if they are doing that, they might as well then bilaterally agree to grant the treaty benefit. So I'm not very optimistic about the prospects of the MFN clause, but certainly work needs to be done to find a way of bringing more consistency and certainty for these entities.
Right. The session C talked about the tax residence of various entities, especially the corporations, and basically the two approaches, place of incorporation approach, place of effective management approach, and how do you resolve the issues around dual residence, determination of residence. India, incidentally, so far has a very sort of narrower definition, unlike the other aggressive positions that India has taken on the wholly managed concept for companies' residency. In the direct tax code, it's been
right, to the place
slated.
of effective management.
Yes, direct taxes code proposes it to extend it as a place of effective management. So panel discuss pros and cons. Do you think India is ready for a POEM concept, or we should continue with the wholly managed concept for companies?
Well, at least for the time being, continuing with the wholly managed concept, it gives the certainty. And eventually, I have no doubt that we will move towards the place of effective management. But probably we should rather wait till we have the new tax code in place.
Right. And the seminar that most of the people were looking forward to, judges seminar, which is happening after a long time. Any interesting insights that you picked up from judges from their experiences?
So there was a very interesting comment by one of the panelists, and he did say that many a times when the judges walk into the chambers or when they walk into the court, they have read the case and they largely know what the outcome is going to be. And then they are just finding for the ways and means of what is going to help them reach the decision, which was a very frank and open view to share. But it is true that sometimes the commentaries help them reach the decision, and sometimes the commentaries are not very helpful. So whether to rely on the OECD commentaries or not often becomes a debate, and the courts tend to take a differing view on that.
Right, right. So the third day of IFA Congress, the second day of technical session, it continues to be a treasure of tax issues. Tomorrow there are two interesting sessions. One is on BEPS, of course. We've been hearing about it, contrary points of view, and second session on UN and OECD update on transfer pricing. Any particular session you are looking forward to, Shefali?
Definitely the BEPS one.
Okay.
I think that is the talk of the town, and we have to see how confident both the OECD as well as the governments and the tax professionals feel about the prospect of BEPS.
Right. I'm sure Taxsutra BMR newsletter on scaling BEPS, which was released yesterday, is something which will give some interesting insight as well. Thank you so much, Shefali.
Thank you.
Hope to catch up with you tomorrow as well. Thank you.